This is the first time that we've been able to get the Lancaster people to attend our UCLA's here. We're Skyping to them today, so they're watching us as we do this. So it's the first time we've done it. Hopefully it'll be successful. They've kind of been left out of the loop as we have these seminars. Today we have with us retired Judge James Gray. Some of you have seen his Daily Journal article and understand that Judge Gray has been a retired judge, was a judge since about 1983 in Orange County. Prior to that, he was a civil litigator and was also a federal prosecutor. So Judge Gray has seen lots of different ways of looking at the courtroom and evidence. He also presided at some time in Orange County in dependency cases, or 300 cases down in Orange County, so he's familiar with the dependency law. Judge Gray is also an author, and for all of us that know about our marijuana cases, Judge Gray has written a book, Why Our Drug Laws Have Failed, and so he's very well aware of the problem of overfiling of the kinds of cases that DCFS files. In addition to that, he's the author of a book called Wearing the Robe. We have purchased these books. If any of you would like to have one, we're going to give them to whoever contacts Daisy, and she will give you one of the books that Judge Gray has authored. Today he's going to speak on direct cross-examination. Hopefully all of you, even the more senior attorneys, will be able to get some good information out of this. Judge Gray is now a mediator and arbitrator, so he's willing to take any questions that you have. You can interrupt him at any time, and he'd be more than happy to answer your questions. So, Judge Gray.
Thank you, and it's certainly a pleasure to be here with colleagues, and I will tell you what I told Ken. I truly believe that the 300s, the whole situation regarding dependency is the most important judging that goes on in the country and the world today. It's where we really should have our most experienced judges, the most experienced litigators, because these are clearly the issues that affect our country in a great deal of ways. If we lose the kids at this point, they'll probably become in the 602s fairly soon graduating to adult misdemeanors and felonies and the rest. You do really important work. And I used to tell the team of attorneys that would work on these cases that, at least to a major degree, we're all on the same side in this issue. And I hope that you exude that point of view as well. We all view it to be a victory if we can keep or bring back the custody of these children to their parents. Now, obviously, we want the children to thrive. We don't want them to be abused. We all know that. And honestly, if your clients, the parents, are likely to abuse their children, it isn't doing anybody any favors to bring the children back into their custody. So I understand that you can't give up the ship and agree with that, but you certainly could understand that. The thing that you want to keep in mind as well, from the beginning of when you get your clients, is to form a theory of your case. It can be continuing to expand. You can have 2 or 3 of them if you want. It can change, but you always want to have that theory in mind on everything you do, on motions that you make or don't make, on objections that you make at trial or don't make, questions that you ask of a witness or don't ask. Will it further my theory? Will it help me to establish my theory? And that is true throughout your preparation, throughout your presentation of evidence, in your argument, and even on appeal if in fact it goes there. You will want to prepare your clients, your parents, with that in mind. Of course, they will have more of a theory. You have to divine it from them. And then you want to work with them. And I strongly suggest when you're working with your parents that you tell them, you know, the truth will not hurt us most of the time. And that's, I will leave to you to decide when it might. But the truth will not hurt us. Yes, there was a problem here. Yes, there might have been a problem there. We will work with that. I can tell you my honest opinion that the 300s is the best statutory scheme I have ever worked with. It really does try to bring the children or keep the children in the custody of the parents. And you have, as you know, 12 or maybe 18 months to do that. And it's really an excellent system, I think. Of course, after that, then, as you know, after most of the time, 12 or 18 months, the focus shifts to what's in the best interest of the children. Your parents, your clients should know that, and they should be amenable to working with whatever those problem areas are to show the court, if need be, county council, is it county council that prosecutes here? County council as well, that you have met those and that it is in everyone's best interest to bring these parents back into custody. The truth can't hurt us, and in their testimony, you're going to want your parents, your clients, to acknowledge the weak points, particularly at the beginning, and then, of course, focus on them. You may very well, you heard Ken mention, I did something extremely unusual for a sitting trial court judge. Back in 1992, excuse me, I'm just getting over a cold. Back in 1992, I held a press conference stating to anybody that would listen, our nation's drug policy had failed and we simply had to change it. We had to put our heads together and come up with something different. And there were times on the 300s, let me get some water. There were some times in 300s that you would have a parent, I remember several, usually fathers, who were using marijuana. And eventually, you know, just because you use marijuana, even regularly, does not mean necessarily that you're not going to be able to take care of your child. Unfortunately, our system sometimes equates that. Well, immediately, if you can show that the person is continuing to use marijuana, we're going to take custody away. I think that's a shame. Just like with alcohol. Maybe sometimes yes, maybe sometimes no, but the system is imperfect. I'm sorry to have to reveal that to you. And it may be that you have to tell your client, father, it's going to be a choice. You're either going to have to give up your marijuana because you will be drug tested and it will stay in your system for 30, 35 days. You may have to give up, take the choice between continuing to use marijuana or having custody of your child. You choose. I hope I know the decision you make. I think that's an unfortunate choice. I think that's an inappropriate choice, but nevertheless, that's what you're going to have to be telling your clients. Excuse me. So, oh good, thank you. Direct examination. First of all, if you have questions while we're going, please feel free to ask because I'm here to try to discuss what you want to discuss. There's some nice seats right here in front. Don't be bashful. What is the difference between direct examination and cross-examination? Because there's a major, major difference in the preparation as well as the execution. In my view, the difference is, you all know what a megaphone is. A megaphone is round, it has a small end and a large end. Direct examination is the small end of the megaphone. What heaven's name does that mean? It means that you ask just a short question, asking for information. And then the answer comes out to be the large end of the megaphone. So what is the very best direct examination question you can ask? It basically should be compound. Who are you? How are you in a position to know something that will help me as the finder of fact? And third, what do you know? So the best direct examination question is, in effect, what happened? 2 words. Calling for a narrative? Absolutely. That's exactly what you're trying to do. And in fact, if you could, you would ask one question. What is your name? Who are you? How are you in a position to help us, and what do you know? And then sit down and let that person talk for 3 hours. Now you're going to get an objection, calls for a narrative, and that would be correct. But you are vouching for the credibility of the witness that you called. It's on direct. And therefore, the whole purpose of this is for you to be quiet and your witness to talk as much as possible. So they talk for a little while, and then what's the next question you can ask? And then what happened? What happened next? Don't interrupt your witness. Sometimes, you know, they're getting along fine, and the opposing counsel is kind of asleep and letting this narrative go on. It's, oh, well, let me interrupt you for a minute, and we'll come back. No! If they're talking and it's helping and it's getting this information out, let them go. Take notes. If you need to fill in something in the future, come back to it, fill this in and add clarifying questions there, but let them go. It's stupid to interrupt your own witness assuming that they're on the right track and talking about what things would help you. There are 3 phases of direct examination. We've already discussed them. But usually attorneys bounce across and go across too quickly the first 2. You know, if you say, what did you see when you were standing at that intersection, Mr. Neutral Witness, when the collision occurred? Oh, I saw this and I saw that and I saw the other thing. It doesn't really help you much, even though it's favorable testimony. Why? Because the finder of fact, you don't have juries, but a jury or the judge wants first to know who this person is. So the first phase of your direct examination question is, who are you? And it's really important to ask that for 2 reasons. It will bring credibility to, or bring help to the finder of fact, and also, much of the time, as you have seen, your witnesses are going to be nervous. Either your parents, their clients, or others that you call. It's foreign to them, it's antagonistic to them, so you want to let them settle in, to get comfortable. And what is the best way a person can get comfortable in court? Talking about something they know about. And what do they know about most? Who are you? So, get some background information. How old are you? Where do you live? Yes, you're the father of Johnny. How long have you been married? All this sort of thing. It's helpful, and pretty soon they'll get into the flow also, and they'll be able to be more comfortable. Always in your preparation for your witnesses, tell them 3 things when you get a question. What's that? Listen to the question. Think about the question, and then answer just that question. Okay? Please, ma'am. I have a chair right here for you.
Thank you.
Feel free. Listen to the question. Please go over this every time with anyone that you might call. Listen to the question so you understand it. Think about the question so you can frame the answer. And then just answer that question. And then what do? Shut up and wait for the next one. Don't worry, the next one will come. Okay? What is your name? My name is Jim Gray and I live in Newport. No. You were just asked your name. Okay? It's really important that they get that frame of mind. Okay. So the first phase is, who are you? The second phase is actually not that difficult in your clients, but how are you in a position to know something that will help me as the finder of fact? Now you're going to call other witnesses in addition, of course, to your clients. You need to let the finder of fact know if this person was a neighbor, or was a nanny, or was a relative. Okay, that's wonderful. Now we know who you are. But how are you in a position to be able to have some information that will help me make a decision on this case? So yes, I am a neighbor, but I would spend a lot of time over at the house, or I would see them, or I would go out to the park, whatever. Establish that. How often do you go to the park? You know, every Friday I would go to the park with this child and would do whatever. You have to give the finder of fact some information as to why they knew something that will help. Because if they say, oh, this is a wonderful parent, you know, she wouldn't, oh, any problem, I'm sure it was an accident. Okay, I mean, that's fine, but it doesn't help you unless you knew that person was in a position to know that. Okay? And then finally, of course, the third issue is, what do you know? So that is direct examination. Cross-examination, completely different. Cross-examination is the large end of the megaphone. Here, you, as the cross-examining counsel, are going to ask a question that is going to get more and more specific and more specific, so that the answer will be at the small end of the megaphone. Usually, and almost always in correct cross-examination, will be yes or no. But, as a judicial officer, I know a lot of people have said, you know, if I ask some rambling question to say I want a yes or no, you have to be fair to the witness. And by the time you've asked your question, you can't repeat it and make it more fair. If it's unfair to the witness to say yes or no, the witness gets to explain. Okay? So what do? You take it in small sections, right? No example comes immediately to mind in a 300, so I'll say in an automobile collision case where you have a neutral witness standing on the street corner, and you see from the police report that she wasn't wearing her eyeglasses at the time. She does wear glasses, she wasn't wearing them. So you say, ma'am, the time that you were standing on that street corner at 6 o'clock in the afternoon on Tuesday the 13th, whatever it would have been, you were not wearing your eyeglasses at that time. Then you finish it always with a statement like, isn't that right? Isn't that true? Weren't you? Whatever. You always finish your cross-examining questions with a statement like that. And then regardless of, oh, I can see without my glasses, or I was almost put them on, or I heard them. No. In fairness to the witness, either the witness was wearing glasses or was not. It's still fair to the witness. You can always explain when you have redirect, but a fair statement to the witness still is, yes, I was wearing my glasses, or no, I wasn't. And by the way, in cross-examination, you pretty much always, if you can, and you pretty much can, you want to have something in your pocket that will impeach that witness if, in fact, you get an answer that surprises you. So, if the witness says, yes, I was wearing my glasses, you have the police report, and at least you can go through that and impeach the witness. So you always end the phrase with, didn't you? Isn't that right? Isn't that the way it happened? Sort of thing. And that will level that attention to the yes or no answer. Okay? You are not standing for the credibility of that witness. You want to take control. You want to be the one in command during these things. It is frequently and disturbingly common to have people, counsel in cross-examination, feel that they have to go through every single point that was brought out on direct examination. And you know something? You're really hurting yourself. As a finder of fact, it really counts for a lot more if the opposition solidifies this particular evidence than if the proponent does. And if you're going to go through without having an ability of scoring a point or two on these particular types of evidence, you're hurting yourself. So, what do? First of all, you plan it out in advance. Cross-examination does not just happen most of the time. You plan it in advance. And if you only have 3 issues that you can show where the witness wasn't quite clear in the testimony, or was even maybe mistaken, or even false, even if they're small points, just raise those 3 points, and then what do? Sit down. Okay? If that's the best you can do, planned it out, you see a prior inconsistency, you see something in which you'll have 2 other witnesses show that this witness's testimony was not true, or was mistaken, or whatever, just raise those points, and then what do? All together now. Sit down. Do not go through anything unless you can score a point. And if you have none, I mean, you ought to be able to come up with something. Don't cross. I have. Oh, also, you virtually never want to ask a why question on cross-examination. Social services officer, why did you believe that my client, the parents, were harming their children? Why don't you want to ask the social services officer, the police officer, whatever, that question? Because they'll tell you, and you don't want to know. You don't want to hear it. Okay? And if they say, oh, there were 5 reasons why I felt that this child was unsafe in the custody of her parents. Guess what? If you've asked that question, this witness, if they do it right, should be able to go through each and every one of those 5 explanations. Why? Because they're answering your question. And if you then try, oh, well, let me interrupt you. No. You ask the question, and in fairness to the witness is entitled to answer the question. So you don't want to ask a why question, except on occasion there are times in which if you ask why in a particular area, be specific, whichever way it comes out won't hurt you. If you know that in advance, okay. But you just don't want, sometimes on the bench I just shiver because you knew what was coming. And they would tell you. You don't want that to happen. I'm here to give you a secret also. I shared this secret when I was on probate as well, which is even more appropriate. Even in 300 cases, the evidence code applies. The evidence code applies. Use it. And if it's hearsay, oh, I know, it's just us folks here, and there's no jury, and da-da-da-da. No, objection, it's here. If it hurts you, it doesn't hurt you, you know, it really does make a difference. If you can establish yourself as a trial counsel to your finder of fact, to your judge, every time you say something, it's worth listening to. So don't make objections just because you can, just because they can be sustained. No. Every time you say something, it's worth listening to. There are attorneys like that. There are also attorneys on the other end, and you know, you just eventually kind of tune them out. You're human too. So if it matters and it is a valid objection, raise it. And number one, you may help yourself at the trial, and number two, I know that a lot of 300 cases are appealed, and if in fact this is hearsay and it's material and the judge makes a mistake and lets it in on appeal, it should be overruled. And then that evidence would be gone. Raise it. And speaking of on appeal, you've got to be aware of your record. You've got to be aware of your record on appeal. How many of you have read transcripts in which it's just fine during the testimony itself? Well, I have a chart. The chart is, we don't know what chart it is. Is it Exhibit Q, Exhibit A or something? No, we don't say, but okay. So I don't know which chart it is when I'm reading the transcript. And then, well, will you go to the chart and you see where you were on that night? Yes. Well, where were you? Well, I was right here. And then, well, what'd you do? Well, I went over to there, and then I went down to here, and then I saw. Okay, and they're pointing during the trial, so people in the courtroom see where it is, and they understand. On appeal, you have no clue whatsoever. And sometimes I, as a judge, would say, well, for the record, does that mean that you started on the upper left-hand corner where it says, would you draw an X on the chart? Whatever. But make it so that you can understand that on appeal. And that will make your life ever so much simpler. Remember your record. So you think of all of those things while you are, in fact, in trial. Are there any questions so far? There's lots of people here. There's lots of things to cover. But I want to talk about what you want to talk about. Bashful attorneys? Okay. When you are in trial, when you're in your direct, when you're in your cross, I recommend strongly that you keep 2 sets of notes. It's not like keeping 2 sets of books, by the way, but keep 2 sets of notes. And one will be the questions you're going to ask in your observations, in your cross-exam, and all the notes that you're going to keep on. And then, in fact, when I was in trial, I'd keep 2 pads of paper. And one pad, even in a week-long trial, maybe I'd fill up one page on the right side of that notepad. And that is just the little points. The points that you could gloss by otherwise, but just the ones that show a state of mind. The ones that can just be a little bit helpful in showing what happened. Just the little insights. And then you're going to want to consult with them when you prepare your closing argument. And you don't want to forget them. And if they're in your regular pad of notes, you can put stars by them or underline them or something. They can get lost. What do I mean? I was one time when I was a federal prosecutor in the U.S. Attorney's Office up the street. We prosecuted a man who was actually the head of laser beam research at TRW. And he was found by the FBI to have taken a whole lot of equipment from TRW, which was government equipment, and he had it at his home in his garage. So they found it, they got a search warrant, they did all that sort of stuff, and then we prosecuted him, and his defense was, oh, I was going to give it all back. It was really just kind of loaned, and I worked a lot during the weekends, so it would be a lot more expeditious for me to do my experiments here in the weekends at home instead of at the office. Okay, and that's a viable defense in kind of an arcane way. But we found during the search that he also had stolen a telephone. And so on my little right-hand pad of notes, took the telephone. Now this was easily the least expensive piece of equipment that the guy took, but it spoke volumes to the jury about his state of mind. Okay? Not something you want to forget in your closing argument. So anytime that you score this little point, put it on your separate pad of paper so that you're sure not to miss it in your closing argument. And then, by the way, when you get to your closing argument, again, you don't have juries, but it's probably true with judges as well. If you don't mention a particular exhibit in your closing argument, probably the judge will not consider it. Probably the jury won't consider it if you have one. So understand that these little points can really, really score for you. And if you have your parents who have done these things and those things, obviously the county council will bring out the poor things, but make sure that you keep that running list of points in your favor. Little insights, they don't have to be major, but little things that will just show the state of mind, the actuality, the support system, whatever it might be for your parents, for your clients. You do such important work. I hope you realize that. I hope that when you, in fact, I know Mike Nash. I've known him for years, and he is Mr. Juvenile Court in Los Angeles, and he's been here for a long time. Len Edwards, if you knew him from up in San Jose area, also was a Mr. Dependency and Mr. Children's Court judge. Or Jaime Corral was also here, I guess, for a while. How many of you knew Jaime, Judge Corral? Good, because he's been quite a help to us. Is he still around, or is he retired?
He's doing ADR work.
Oh, he's doing ADR work. He's gone to the other side. But it really is exciting and important work. When you talk about your theory in preparation for your trials, talk to your clients about it. Develop it. You know what the system is. You know what the statutory scheme is. But try to, as much as you can, speak with your parents so that you can bring out the positive things, the little things, and have them, again, when you're preparing them, tell them to tell the truth. You must know that, because it really, I've had to take away, terminate parental rights, all that sort of stuff. I've done it with tears in my eyes, literally sometimes. I know how important it is, and I believe your judges will take that seriously. They want to support your clients. They want things to work out well. So they need to have these little points, these bigger points. They need to have your clients get on board the system. And if they don't tell the truth, and if you don't tell them that, a lot of these people, you know, they're just not accustomed when the heat is on to actually coming clean and answering a question truthfully. And if they don't tell the truth, you're going to really hurt their chances. So you've got to get with them, hold their hands, sometimes even in preparation when the courts are closed and the the judge is off the bench or something, take them into the courtroom. Let them see where this is. Tell them where this person will sit and that person will sit, and this person will do this and that person will do that. You want to make them comfortable. It's very similar to when they finally get in the witness chair, to asking them to explain a little bit about who they are, etc. It makes them more comfortable. It makes them show that they are more self-assured. And then have them listen to those questions and answer them. Go over these various points with your parents. It wouldn't hurt, it seems to me, to share those points with county council, with the social workers. You know, if they're positive, you can try to get the social workers to work with them anyway, and to field them. There are other things too. I don't know what happens here in Los Angeles. I do know that down in Orange County, we had a social worker that actually had a parent, and the problem was, and the reason that they took the child from the custody of the mother, was that they had broken windows in the house. And that, you know, it was unhealthy. The child was cold or whatever, and they had broken windows, and the mother wasn't fixing them. And I hope you realize, just like we did, that going and fixing the window wasn't going to help the problem. So what you did is, and I instructed the social worker to take the mother by the hand to Home Depot and to measure, first of all, measure the place for the window, figure out how much it was, and show them how to clean it out. Had her take out the old window, the cracks, cracked glass and everything, go down to Home Depot, purchase the window of that size, get some putty, get a putty knife, and come back and actually replace the window. And as soon as that happened, then not only, because if this ever happened again, that was the type of neighborhood she was in. So at least the mother would know how to do it. And that was the only problem. What a catastrophe. What just to take away a child because the mother didn't know how to fix a window. So we can get into those sorts of things. That's what you plan. If that's your theory, that's where you go. Yes, ma'am.
What do you do when you have a judge who likes to become an attorney, and if the county council's not really proving their case, there'll be a witness up there and he starts taking over the cross-examining? I mean, you always can make the objections, which you should.
Yes.
In their authority, sometimes I can understand that when you get to the end of cross-examining or direct exam, they want some clarification. But when you have a hearing officer that, for whatever reason, you ask the witness their name and suddenly starts taking over everything, how can you sort of shut them down in a nice way, and then, say, well, your honor could be put on a case? Because a lot of times, if you're doing it properly, you know what you want to ask, and you know what you don't want to ask. And I feel that they're up there to get the evidence, whoever, has the burden of proving it, and then, we are defense. But I don't think, personally, they should put on the case unless it's clarification. So, any sort of other ways to sort of...
Okay, you asked a very difficult and very practical problem. What happens, just so all of you can hear, you probably did, if you have a hearing officer, and you haven't seen this before, in which the hearing officer simply becomes, leaves her position of a neutral and starts cross-examining or bringing out evidence on their own. To some degree, it's certainly more permissible to do that without a jury. I am the fact finder, and I want to be able to have the right information to ask the questions. So to some degree, you have to be patient. But there does come a time. And honestly, I'm going to take a diversion here for a moment. Look at traffic cases. Here, at least in Orange County, and I fully expect in Los Angeles, the judicial officer is the prosecutor. They don't have a prosecutor there. Do you have district attorneys in your traffic cases? I doubt. No. And I think that this is coming where the Supreme Court finally says, no, you have abandoned your neutrality and you're going to have a prosecutor there or the cases cannot go forward. There must be some cases. I haven't looked at this, but research them and have them in your pocket. Have them where you're knowledgeable about, People B. Smith of whatever it is, in which there comes a time in which, Your Honor, and don't say with all due respect, because we all know what you think when you say that, but Your Honor, we are prepared on this case. My personal philosophy was that I would do everything I could, with a jury or without a jury, to allow the direct examination to go forward without interruption. Yes, clarification, was this, the year 2009 or the 2010, that sort of thing, and that's perfectly appropriate. But otherwise, Gray, be quiet. Don't interrupt. hard for a former litigator to do. And then in cross-examination as well. But after direct and cross, if there's no jury, I feel it's appropriate for me to ask my clarifying questions. And I think that it's only appropriate for you as counsel to say, Your Honor, we are prepared. My cohort here, or my opposing counsel, is prepared. Please let us present the case to you, and only after we finish, then if you have clarifying questions, of course, feel free. I don't think that a judicial officer should receive that badly. Also, though, if they do get too carried away, cite that case law to them. On the record, make your objection clear, and that is a definite point on appeal. And I promise you, in traffic cases or in these cases, the time is coming in which the California Supreme Court will agree with you and will put a muzzle on it. Yes?
Well, I think you just answered that. You know, our concern is not with our direct, it's when they take over basically the direct for county counsel that has done nothing, and they start doing basically a cross-examination of our clients. And I do object when the question is in violation of the evidence code, but beyond that, it's pretty hard to stop them.
Well, you know, you can't pick up a meat cleaver and threaten them. You know, there's only so much you can do, and that's what the appellate court is for. I appreciate the fact that it's going to be months, you know, that the judge is going to rule however the judge rules, and if, you know, the custody stays away. All you can do is you've got to keep your own ethical proprieties as well. But we all know, wearing a black robe, I hear objections all the time. But sometimes if there's really spirit behind them, it gets your attention. And Your Honor, you are becoming the prosecutor in this case, and it is inappropriate based upon United States or People versus Smith or whatever. And I vehemently object. I don't think there's anything to matter. You know, an objection is supposed to be either yes or no. But you know, we vehemently object to your continuing to question because you're losing your rule of your neutrality. I think that that's what I would do, and I would recommend it to you. It's hard being a judge. Again, the leeway is greater if there's no jury and you don't have a jury, but these are problems that we have. Others? An awful lot of people here, but very few questions.
I do have a question. On cross-examination, there's always the statement that you should not ask a question unless you know the answer. Do you feel that is correct? Or?
Ken asks if, in fact, I agree with the old saw that you do not ask a question in a cross-examination unless you know the answer. Of course, the answer is always except when you have to. Sometimes, as I tried to say earlier, it won't hurt you one way or the other. You know, how are you feeling that day? Well, okay, you can find out. But you really, if it's an important point, you're flirting with disaster. If you're already up against it and you have nothing else to go with, then sometimes you have to take a chance. But you should, first of all, it just shouldn't be off the cuff. You will have planned this out beforehand. You will try to be able to learn the answer and figure out or be able to impeach in the event that you get an answer that hurts you, etc. It's really flirting with danger. Sometimes you have to, and we all appreciate that. But basically the question, the answer is don't do it. Don't do it. Yes, sir.
Because I sort of think cross-examination is more art form than sometimes practice. In working with the new attorneys, how can you train to sometimes less is more with cross-examination? Because to follow up with Ken saying, because you don't know, and we don't have control completely of what the answer is going to be, how do people fine-tune their cross and know what might be the perfect time to just stop?
The question is, in training new attorneys or anybody, or just your own practice or trying to mentor others, how do you know, how do you gain that confidence and art form in making your cross-examinations, and how do people know when to sit down? I think the best way of doing it is make your points. Figure your points in advance. You should be able to know you're going to have reports, you're going to have statements, you're going to have these things. It happens before you get to the courtroom. figure out what your points are. If another one occurs to you or comes up with the direct examination, fine, add it. But you're not dumb if you only ask 2 questions. In fact, you're probably dumb if you ask 3, if you only have 2 points to raise. Get in, get out, and sit down. You sit with somebody you're trying to mentor or trying to teach. The nice, clear teaching form is get in, get out, and sit down, and then use it on your closing argument. And once you get a point, oh boy, I got to ask it again? No! You're giving the person a chance to clarify, or to explain, or to, wiggle room. You get what you want, move on, or sit down. So it's really not that hard. And once you get in, you talk about the form, once you train yourself or explain yourself to others that every question in cross-examination ends with, didn't you? Isn't that right? Wasn't it? That sort of thing. That will help a great deal, because it really should be yes or no once that is done. And if you've done it right, where you've taken the large end of the megaphone, and by the time you get to the small end, even in fairness to the witness, the only answer is yes or no. And then you take the next small step, ending with, isn't that right, once again. Okay? It really shouldn't be that hard. But you can see those awkward silences again, or, oh, I've got to do something. So you go back through the whole litany and you just pound those nails in even harder, and it really hurts. So this can be done. Yes, sir?
Could you touch base on cross-examination of children? Something that we deal with, a lot, differences between handling an adult with a child.
Yes, the question is, how can you handle the cross-examination of children? And the answer is delicately, of course. And there, each question is going to be different. The judge should have, before the child even started, should have established, because they're not going to be sworn in, depending on their age and stuff. The judge should have already established that they know the difference between telling the truth and telling something that's not true, giving examples, etc. If the judge hasn't, then you can do that. Boy, how do you like my green tie? Oh, no, it is, I'm wearing a green tie, is that right? No, that's not the truth. That's not the truth. I mean, you get really simple with some, 4 or 5, 6-year-old, and put on the record, in fact, show that they know the difference between telling the truth. And do you always tell the truth? And probably they'll agree, no, they don't always tell the truth, and that sort of thing. So you start gently. And then, you can tell them the importance of what we're talking about, and how important it is that you tell the truth. And you don't want to just say, well, did everything you say on direct examination, was that true? Because you know what the answer there is going to be. But you've done, well, now, were there some times where you have said something, Jimmy, and you can call them by their first name, as opposed to an adult that you never do. Jimmy, there's been some times when you first saw something and thought it was this way, and then you found out that, well, no, it wasn't quite this way. It was more a little bit like the other way. Has that ever thought, you come up with an example where you thought that, your sister was watching Howdy Doody, I'm dating myself, instead of, Snowcastle, something else, and then later you remembered. So you gently go in and show them how sometimes what they had said wasn't true. And then just go back in the testimony and gently, because you don't, and obviously it just depends. You're going to say, well, do you love your mommy? You want to make sure you know the answer to that question. Because if the child says, no, she beats me all the time, you might be in trouble. So, but you will have been able to talk with the children beforehand, I assume. Can't you? You can't do that. Okay. You'll have the reports, you'll have information, you talk to your parents, you've got to have your clients tell you the truth. And, in fact, they did some things, they did some things that weren't good or could be misinterpreted or whatever. And then you also want to focus on when they went to the park and they had a really good time at the zoo, or their birthday party was successful. You can divert the child's attention to the time when they went to the zoo and they had a happy time. And then, well, have you had other happy times too? Now that's a kind of, in effect, a why question, but you have to kind of guide them. There's no real easy way. I hope that helps you a little bit, but sometimes you can say, well, it's delicate, because if you say, well, you said that your mommy hit you on last Tuesday or whatever, could you really be mistaken? They're not going to be mistaken, so it's difficult. What do you do? Everybody, people here might be interested. I didn't feel that my answer was as helpful as it might have been. Does anyone else have some thoughts on how you cross-examine a minor child?
I think you try to get them to like, when you're doing it, try to get them to like you and be very gentle at the beginning before you go in for the kill and sort of well, in a sense, you want, if you feel that they are not telling the truth.
I hope everyone could not hear that.
You want them to like you so they feel comfortable talking to you. So when you start going through the allegations that are there, they go, oh gee, was she, because a lot of times I think finance attorneys or the county council will say, well, this person's going to go after you. I know her, she's going to try to make you say this or that. So if you talk to them, you know, the basic little questions, and then as you get deeper and deeper, sometimes they'll open up a lot. But I think they have to have that trust with you, so you can't just be
I think that's clear. She's saying you have to go in small steps. Start with something that's positive. Start with something that's helpful, so that they like you, and they, again, just like when you put a direct witness on the stand, where you make them feel comfortable. You want to make the child feel comfortable with you, because obviously the child is going to be very filled with trepidation in getting into doing that, and then slowly getting into the issues and trying to go from there. Yes?
I think with children in general, I think the key is establishing what you want to get out of the cross. And there may be nothing to get out. I sometimes see people want to sort of go over the allegations or go over their testimony again, and sometimes you just basically reconfirm what they did on direct, and there's no real point to that. Because children, sometimes, it depends on the age, obviously.
There's a point not to do that.
Right, and so I think the key is to establish first in your head what you want to get out of the cross-examination, and you might not be able to get anything out of the cross with a young kid, and then at that point you don't really ask any questions, or maybe a clarifying question, or whatever the case may be.
You know, with any cross-examination, you want to come up with your points in advance, just like you're saying. And they don't necessarily have to be anything that was addressed in direct examination. I think it would be a mistake not to cross-examine a child brought in. There have to be some good times. There have to be some things that will countervail whatever the bad things are that you have heard. And then once they start saying, yes, we did go to the zoo, or I had a nice birthday party, or she cooks good omelets in the morning, whatever it would happen to be, you can extend that a little bit. And then, of course, you will have spoken to your clients first, and you want to get these points. And you know, she reads to me at night. Oh, by the way, please, on that score, when I was on the bench and I was putting custody with a grandparent or something, I would literally have a condition of that custody that they would read to the child. Reading is a wonderful thing. It's a bonding experience. It helps the child from no end. And you know, I bought a case of these books and would give them to the grandparents or the parents or the person in custody. Fox in Socks by Dr. Seuss. What a wonderful book to read. And if it's only a 3-year-old or so, mostly the parents can read, but have the child read with the person, sitting on your parents' laps. And then once you do that, particularly, I strongly commend this to you. If your parents still have custody throughout these proceedings, if the judge starts hearing that when they go to bed at night or in the afternoon, the child is sitting on your client's lap and they're reading and they're laughing, it has tongue twisters in it, it's kind of silly, it's really a wonderful book. If you guys have to invest in a case or 7 of the Dr. Seuss Fox and Fox books, do it. These are things that it isn't just a show, it's really an important thing for the bonding of the parent and the child, and it's a great thing. One of the best things you can do for the progress of a child is to get him or her to enjoy reading and to participate in reading. And so that's something you can bring out. Well, You know, after you've gone through the direct examination and it's been a terrible life up till now, but the child is still with, or even if you visit the child at your equivalent of Orangewood or wherever it is, if they're reading to the child, then you can say, well, is your mommy reading to you now? Oh, what book is that? Oh, it's Fox and, oh, did you like that? Was that fun? Did you enjoy doing that with your mom? You know, that sort of thing. It brings out things positive, and these are within your control and things that will really, I think, make a difference with the judge. Yes?
To me, the biggest thing with children, there are 2 points. Their concept of time is totally different than anyone that's sitting there. So you've got to try and break through on the idea of time and get down to their position in terms of time, so that you can kind of straighten out the issues in terms of timing. Because a lot of times timing is important. A child was struck 6 months ago or a year ago is a lot different than a child struck 2 weeks ago. Then the other thing is their language. You know, they may say they got a whooping. A whooping may be nothing more than a tap to them. A whooping to an adult is a whooping. And so you've got to break through that language barrier and get to their language and get them to color it, because they're going to color it differently. And if you have a real strong feeling that it's not nearly as harsh as it's been made out to be, then you've got to get the child to show that it's not as harsh.
All of this is true, and I hope you could hear the comments, that you do have to address the issues of time. Kids, you'd be amazed, adults. Some people will say, you know, how long did this person scowl at you? Oh, for not very long at all, 5 minutes. Can you imagine? You know, one way you can do it is just ask them to hold their breath. See how long they can hold their breath. You know, all of a sudden 20 seconds is a long time. So, you know, there are ways that you can do this. But children are even worse, and they just have no concept of time, either from seconds, minutes, hours, days, months, or whatever. And also, yes, if you get somebody that says he gave me a whooping, if that's where they left it on direct examination, and you know from the parent, because the parent has told you what happened, and it turned out to be, you know, he slapped his hand or something, which is probably in today's world not necessarily a good idea, but you know, at least get that explanation out there, and find out how many other times have you been whooped, that is, slapped on the hand, and if this was the only one or whatever else, or you know, if you got cigarette burn in your cheek, maybe that's a little bit different, but you know, all of this is true, and these are clarifications that really do have to be brought out. I think it's virtually criminal for a county council to allow testimony, to elicit testimony of a child, or anybody for that matter, that you're going to use the word whooping if it's just something that's a slap on the wrist. I think that county council, and you can hold them to them, and you can tell them that I said so if you want to, has an ethical standard that will not quit, that they have an actual, literal obligation to do the right thing for the right reason. It isn't a game. This isn't something that we're trying to show how good a lawyer I am so that I can take the children away from the parents' custody. They have an absolute obligation to do the right thing, to be truthful, and to provide all information to you before this sort of thing happens. And you can get up on your righteous indignation horse in front of the trial court and demand that and say that this is not happening on this particular occasion. Look at what they have done here, and you should, Your Honor, you should take this evidence into account and assess it with that in mind. And I would, if I were having a whole room full of county counsel or prosecutors, the U.S. attorneys or otherwise, it is an absolutely sacred obligation that cannot be breached even once if they breach that obligation of honesty and truthfulness when you're talking about children. And do it, and mean it, and I know you will. No? Okay. Any other questions? Direct and cross-examination. Your theory, again, is so important. It's so obvious sometimes as a judicial officer, and there's not much I can do. I can ask questions. I tend to ask a lot more questions to clarify on how the bad thing did not happen, and that shouldn't upset you. I want to make the right decision. Put yourself in my place. I'm sure many of you have tried. In fact, I've written a book called Wearing the Robe, where I actually tried to take every calendar. I sat on all of them except family law. Actually, I talked to a few colleagues and tried to get some examples of family law and the rest of that just to put into my book. And one of them was, You know, sometimes, some cases, they just argue about everything, and that's just what they do. And the biggest extreme of that, a friend of mine told me, was that at the very end, they'd gone through everything. They argued here and they argued there and everything else, and finally the last remaining argument was who was going to have custody of their wedding photos. I thought, wow, after all that. But, you know, sometimes those things happen. Sometimes they'll happen in your cases as well. But as a judicial officer, I would try as much as I could, if I felt that what the, like with this social services officer that took away custody of the child because the mother didn't know how to fix a window, you know, I'd take charge and would try to make the system work. In fact, that is my theory of the being involved in as a judicial officer. Make the system work. That should be your theory as well. Make the system work. We are here to bring custody back to the parents if at all reasonably possible. Make the system work. That means the county council has that task. It means social services has that task. It means the judicial officer has that task. And it certainly means I have that task as well. It is your function to make the system work. I truly believe that this statutory scheme is as good as any I've encountered. I hope that you agree with me. Sometimes it doesn't bring the right results, but it's pretty good. But we've got to do what we can to make this system work, to bring this help to the parents. You've got to get the parents to the understanding that we're not against you. We are in favor of you. We are applauding you when this system works. We will have tears in our eyes if it doesn't, although that doesn't keep us from doing it. But you've got to get the parents on board, and your theory will help you do that. So that is my view. If there are no other questions, I'm going to get back in my car and take care of my cold and go home. I do have some of these books if somebody... Honestly, you can only be as good an attorney or an advocate as you understand what the judges are going through, and so I kind of wrote the book with that in mind. There is a chapter with regard to dependency and virtually everything else. But I love our profession. I will leave you with a story that I was one time at one of these fundraisers, and sitting next to a woman who found out that I was in the legal profession, and she just regaled me throughout the entire evening of dinner on how the shyster lawyers are involved with this and everything wrong is from the legal profession and those stupid lawyers and greedy and all the rest of this stuff. And finally, literally, by the time we got to dessert, I desperately tried to change the subject. And I said, well, ma'am, do you have any children? She looked at me and she said, oh, yes, and my oldest son is in law school. I thought, you know, it's true. There is a reservoir of goodwill for our profession. People know that we deal in disputes. They know that we are trying to work things out and to make the system work, etc. But I am enormously proud to be in the legal profession. I am proud to share thoughts with you, and I appreciate the opportunity to come and do that. Good luck to us all, and let's get it done.